Welcome to Disunion, the Government Union Report, the podcast where we delve into the ever-evolving landscape of public sector labor policy and law. Richard A. Epstein is the Lawrence A. Tisch Professor of Law at NYU School of Law and Senior Research Fellow at Civitas Institute. Epstein is also the James Parker Hall Distinguished Service Professor of Law Emeritus and a senior lecturer at the University of Chicago. He knows a great deal about this subject, public sector unions, not only as a result of his scholarship, but he happens to be sitting in New York, one of the states dominated by public sector union interests. I've been looking forward to this conversation. Professor Epstein, thank you for joining me.
It's my pleasure.
Professor Epstein is well known for bridging the disciplines of law and economics, which will be our focus today. Before we get to public sector unions, I think it'd be helpful to go back to the beginning of unions generally, which is to say private sector unions. Mm-hmm. Can you give us a description of the initial problem that unions were supposed to address, and then how that ended up working?
Well, it depends whether you think of the problem as a social problem or as a private problem. Unions first came around as early as 1806 in something called as the Cordwainer cases. And it was always the question under those circumstances as to whether or not when a group of workers got together, whether or not through a formal union and decided collectively to withhold their services, whether they would be allowed to do so. And if you were to treat this as a matter of antitrust law, which was at that time in its nascent phases, the general rule has always been individuals may decide to do what they want to do, but when they get together horizontally, that is when they're working the same way in the same kinds of jobs, that gives themselves a kind of a monopoly power, and that creates a certain inefficiency because the number of jobs that will remain will be small, the wages will be high, and the deadweight social losses will come from the fact that there are many firms that could afford to pay a competitive wage that cannot afford to pay a monopoly wage. So that's the first problem. The second problem that one always has with respect to unions is their internal governance structure is a very difficult thing to organize. They are not a simple cartel, as is the case, say, with oil companies and so forth. And so what happens is in order for this to work, they have to make sure that all of the existing members play in the game. Otherwise, if what they do is they organize successfully, have management recognize them, and then fire 20% of the people who voted for them, it's not going to work. So what unions do, therefore, is they create a very inefficient work structure in order to make sure that everybody has a part to play in the overall adventure. And so whenever you look at union contracts, you will always see that the workers are siloed into particular tasks, and you can't have somebody come in and say, well, I can fix this cabinet, here's what I'm going to do for the electric, and here's what I'm going to do for the woodwork. You're going to have to hire the guy who does the electric and the guy who does the woodwork. And these kinds of job segregation situations therefore impose very heavy costs upon employer. So is this just a question of employer against employee? And the answer is of course not. These people now have to go out in the world and to sell goods. And the goods that they're going to sell are going to reflect the impacted cost of the unionization process, and they're going to cost more than would otherwise be the case. And so what will happen is there will be fewer sales at higher prices, which will result in some form of consumer detriment. Now that's the optimistic story, because when you start with union, the original impulse was you're doing this with respect to guilds that engage in various forms of manufacture, where this particular model works. But as you start moving forward, particularly after the Civil War, what happens is the dominant industry in America becomes the railroads. And this is a very complicated industry because you have all sorts of interconnects and switches and so forth. But for these purposes, the key difference between a railroad that supplies the transportation services or a bus company or anything of this sort is that if you're in a manufacturing business and you're going to face a strike, the manufacturer can speed up the construction lines, hold a reserve of goods, the workers can get a strike fund, and so they could have a strike that lasts for a long time before third parties are going to be adversely affected. But the moment you have a transportation strike, if it's called at 12 o'clock, it's effective at 12:01, because what it does is it shuts down the system, and there's no storehouse of transportation rides that you can use to fill the gap, so the dislocations are immediate. And when they're immediate, of course, what happens is the major party who suffers are all the consumers and commuters who can no longer get to where they have to go. They can't send their children to school and so forth. The buses won't take them. The railroads won't take them. They have to stay home. They have to call in sick. All sorts of other things start to happen. So the impact of a union with respect to an industry in which there's no storage is absolutely emphatic. So what do you try to do about this? Well, it turns out that if you go back to the period around 1920 or so forth, it became very clear that industrial unions of the traditional sort were gaining favor, particularly with Roosevelt and company. They were the darlings of progressives like Felix Frankfurter and so forth, although he turned against them in his later years because he realized what the inefficiency turned out to be. But there was on Roosevelt's part a great reluctance to have public unions. And when it came to railroads, people realized that the old regime would not work because of the threat of a strike shutting everybody down. 1926, we passed something known as the Railway Labor Act. And this introduces a completely different scheme. It says, in effect, you can't fire the workers and they can't go out on strike. And so what happens is you have this bilateral monopoly. And if a firm wants to introduce a new technology, say a diesel engine as opposed to a coal-fired engine, it cannot do so without the consent of the union. And so what you do is you get these massive holdout problems. And what this means, in effect, is that you have to pay huge numbers of people to stoke coal. Then it turns out it's even if you have to pay them, you'd rather they do nothing than work. So you put in the diesel engine, and these guys have legacy jobs which are totally useless. And this is the function of a holdout system. And so what they did in the railroads is they solved the problem of immediate destruction of the market by imposing essentially the stranglehold that unions have with respect to firms. Roosevelt comes in, and he does little, if anything, to deal with the two private sides. But there is then the question, what do you do about the National Labor Relations Act? And the reason why this is important, because now instead of just having unions out on strike or not on strike, the great conceit of the Wagner Act of 1935 was that we could figure out a way in which to structure collective bargaining so as to avoid truly egregious situations, like that you have in Britain where the Trade Disputes Act of 1906 was such that you couldn't enforce a contract against a union, and a collective refusal to deal instead of being an antitrust violation is now a protected act. And inducement to breach a contract is just fine unless you beat somebody over the head with a mallet. And so the British system essentially went cratered under Margaret Thatcher, and they had to start over again, and the damages are still there. In America, we went the other way. We tried to institutionalize collective bargaining. And so the first choice is what's going to be covered. Roosevelt was very resistant to public unions. His attitude was that if you have a public union, you have somebody bargaining for the government who is not bargaining with his own money. If you have somebody who is essentially in a private union, the union representatives know they have to deal with a firm that has shareholders who could bring derivative suits against them and so forth. And so they're going to face some degree of real opposition. If you have the public unions, what these unions do is they manage to confine a way to elect favorable electors, representatives of one kind or another, so they're sitting essentially on both sides of the table. And Roosevelt was very much against that, because he could see exactly what was coming down the road. But he was strongly in favor of private unions, and it turned out, it wasn't the sweetheart deal that they really thought that it would be. When you have a private union, you still have the bilateral monopoly problem. That is, the firm has nowhere to go but to the union, because the union has the exclusive right to represent all the employees. And the union, of course, only wants to take in the firm. And so the two of them are there, and there's a big bargaining range. And the union may be prepared to accept as little as $10 per hour, and the employer may be prepared to pay $13 an hour. And then where in that $3 range do you end up with the contract? Well, God knows, because there's no unique price as you get in competitive markets. Worse than that is that when you're dealing with a collective bargaining agreement, you have to set not only wages, but also the terms and conditions of employment. And the statute recognized that. But how do you figure out which things are mandatory, which things are optional, and what kind of bargains you have to make on that stuff? Became, again, very, very difficult. And so there were long and contentious fights that started to take place. And all of this was essentially put to an end, at least for the short term, by World War II. The National Labor Relations Act, which required mandatory collective bargaining, was put on hold. And what we did is we had a War Labor Act starting around 1942, in which you had a bunch of very clever arbitrators who said to the union, you can't strike, but we'll pay you a bloody fortune in order to stay on work, which is what happened. And the justification is you need the tanks to fight when you go into Europe. And the truth of the matter is the contracts may have been somewhat exceptional, but the performance of the American workforce in the production during World War II is still one of the miracles of industrial organization, matched nowhere in the history of the world. These guys like Henry J. Kaiser and so forth, they were magicians. They could give you a plane an hour, a tank in 30 minutes, or whatever it was. If you go back and you look at the production stuff that takes place during the war, we were indeed, as Roosevelt said, the arsenal of democracy. We could churn this stuff out. By 1944, the way in which we won the war is for every German plane, there were 10 American planes coming after them. And in that kind of a food fight, the guy who's got all the weapons is the guy who's going to win. And exactly what had happened. So the war then ended.
Let's pause here. Yeah. When we haven't got yet to institution of exclusive representation, you mentioned it, but at least historically we haven't gotten there quite yet. Prior to Taft-Hartley, was there anything positive you could say about the effect of unions for workers or for the economy generally?
Well, the standard argument, they said, was that it would stop the discontinuation of work, which would be a plus, and it would also lead to what they claimed was industrial peace. And so what happens is if you start going back to the 1910s and 20s, there was a lot of violence associated with labor, and it continued throughout this period. And if you think of a lot of songs that took place, like, do you remember Joe Hill? I dreamed I saw Joe Hill last night, alive as you and me. Says Joe, they forgot to kill, went on to organize. He was somebody who was killed in one of these strikes, and they made him a martyr. Mm-hmm. And violence was a constant feature of these particular type situations. Employers used to be able to get injunctions against laborers. In 1930, they passed the Norris-LaGuardia Act, which limited the use of these injunctions, which paved the way for collective bargaining. And so what they hope they can do is institutionalize the arrangement, get rid of the random violence, and have cooperative bargaining. And if you go back and read the literature at the time, there's a famous article by a man named Calvert Magruder, who later was then a Harvard professor and later a very distinguished judge. And he had the most colossally incorrect prediction about how these things would work on the face of the world. And so I will read to you the decisive sentence that he said. He says, now that management has made the concession by putting their best foot forward for collective bargaining, we can accept the union to reciprocate and to be cooperative in their negotiations. Dream on. What he kind of understood, he basically analogized unions to ordinary businesses. And the general maxim when you're dealing with the business and you want to make a deal is you pick your partner carefully and then you put your best foot forward. You've heard the expression, right? Mm-hmm. And the guy sees that and he looks around and he says, hey, I know they've offered me a deal from which I'm sure to make a profit. So I could take it right now or I can bargain. And you may bargain, depending, but not as much as you might otherwise do. Because private parties, if you choose them, they're very leery about the short-term losses that come from protracted negotiation. They know that people have other trading partners in the wings, and so they tend to overcome these bargaining hurdles fairly quickly. My daughter, who's a professional negotiator, she said one thing that always struck me, which is that you'd much rather bargain with a party that knows what's going on than with a party that doesn't understand the industry. And the explanation was very clever. She says the other guys know what the standard terms are. They know how the business deals. And so they can figure out what's a joint benefit and what's a one-man move. Whereas if you're completely inexperienced, you're just thoroughly suspicious. And when somebody puts a great offer on the table, you can't figure out that it's actually a good offer because you don't know what a good offer looks like. But private firms, therefore, when they negotiate, they put forward experienced guys, and generally they can get to an equilibrium more rapid than two rookies. Now, you put the same structure in a union situation. Well, I didn't get to pick my union. They had a bitter organization fight. They came after me. They won. Now it turns out what they have to do is to pay something back to their workers who voted from this. They have to be able to recover their own expenses. You put your best foot forward, they're going to cut it off. And so what happens is you completely change the nature of the bargaining relationship. And what you need now are tough guys who can stand firm as opposed to businessmen who know how to make a deal very quickly because you'll get run over on the other side. So both teams, instead of having cooperative negotiation, you have these kind of standoff type situations in which they're tough on one side and you're tough on the other side, and it leads to either protracted negotiations or often to a breakdown, which in fact then results in a strike or a lockout. A strike of the union workers stopping, and a lockout is a situation where the firm says, we'd rather be without you than with you. And so then what happens? The question as to whether you win on either of these two sides depends on what your close substitutes are. And so there was a very famous instance in the communication industries where the union decided to strike one of the major telephone companies. It may have been Bell Atlantic, but I'm not sure of the particular name. And they said, we're going to go out if you don't do it. What they had not realized was that the company had already mechanized and automated their own system so that, at least for a short period of time, they could operate it with 10% of the personnel that they normally hire. That is, they were subject to a form of feather bedding. And so when the strike went on, these guys put out their own team. They started the work, they kept it going, and the union came crawling back. Why was that? Because they made a credible threat that they can do without them. And so even in the standard bargaining situations unrelated to the Railway Labor Act, there's always some padding that takes place on the employee side because the union dynamic is such that we have to bring everybody into the tent. And so when you look at union agreements, what happens is huge benefits to seniority of workers sitting there, which meaning the younger workers or the new workers are the ones who always basically take it in the chin. Because what the bargaining agreement does is it specifies seniority as a major attribute, which means that the senior workers get a huge advantage and the junior workers get the following advantage. In 10 years, you'll be able to screw 10 people who are now junior to you. That's the way in which the system works. And so the internal dynamics of a union-type organization is strictly hierarchical in terms of the way it works, because the guys at the top have the power and they bargain to preserve their jobs, and they take it out on the young recruits. All of these patterns, of course, exist as well in the public union sector, because you have exactly the same kind of directive, plus the other factor.
Before you get there, did exclusive representation fix any of these problems?
I think it's fair to say it was better than the British system, wildcat strikes, which brought the country down. And I think the reason for the difference is political. In England, they have something known as the Labour Party. And guess what it represents? Labor. On the other hand, in America, it has the Democratic Party, right? And what does it represent? Southern segregationists, for starters, and Northern Unionists. You think these guys have a lot in common? No. And so what it does, in effect, is the union influence was mediated and diluted by virtue of a party system in which they did not have direct political representation. And even when you had presidents who were pro-union, there were people like Harry Truman. Now, Truman was a great president in many ways. I mean, most people don't know that, but he was the single most effective member of Congress in making sure that the war effort stayed on ground and so forth. He was the guy who insisted they build the Higgins boat, which made it possible to land at Normandy. Everything else as a craft would have lasted. He was an absolute genius. And he was very much in favor of unions, and this is what he said. I'm a Democrat, and I'm only going to hire Democrats. But if my Democrats goof off, I'm going to fire them and get myself some other Democrats to take the job. So he had the kind of political bias on the one hand, but the efficiency bias on the other hand. And what happened is he therefore found himself in this very strange position. And so if you go at the end of the Second World War, what happens is all of the War Labor Act stuff removes itself from the picture, right, because it's over. And then you have, in 1945, 1946, what was called the strike wave. Huge conflicts between all these firms, which wanted to keep the high wages. More workers were coming back from the army, right, which would then depress the number of people, the amount of power that you have in the strike, because the new entries are going to change all of that. They wanted to keep the old structure. The firms resisted, and there was this huge breakdown. And there were then two responses to this. One, which is not so commonly known, is called the Administrative Procedure Act of 1946. And do you know what that statute is?
Oh, sure, yeah.
Okay, well, you're a good man guy.
I wouldn't put it in response to this. This is interesting.
Yeah, so what happens is that this is an act which is designed to deal with the way in which negotiations take place through various kinds of administrative boards. If you look at the National Relations Act of 1935, it sets up the National Relations Board to adjudicate cases. Now, the key thing to know about that is they don't use the National Labor Contracts Board. Relationships. A relationship is a term that is defined in part by contract, but in part by the set of external constraints that are put on top of it. And it turns out those constraints really mattered. And so as one started to go forward during the war, and there were some decisions on this, it became very clear that the labor boards were administratively very much in favor of the unions, and that the judicial review of their actions was relatively weak. And the 1946 Act was designed to strengthen the level of administrative review by the courts so that they could have, at least as originally designed, first crack at any question of law that was decided below, and then could review evidence to make sure that when the union won, it was substantial. It did the same thing with respect to employers, but the skew is one way, so the effect of the statute went the other. And Truman signed that statute. But when it came to the Taft-Hartley Act and to the Labor Relations Act on shutdowns, 80-day cooling off periods and so forth, he was resistant and they passed it over his soul. Now, why did this happen? Well, there are two things to know. One is the 1938 election, and the other is the 1946 election. Now, these are not randomly chosen dates. The 38 election took place after the great Supreme Court revolution in 1937, which sustained collective bargaining against the earlier cases, which I continue to support to this very day, which had said essentially collective bargaining was the interference of a right of an employer and an employee to get together and to form an agreement of their own. Because in the interim during the war, Justice Jackson, in a case called J.I. case, had said, if you have a pre-existing contract between a worker and the boss, and the union comes in, your contract is out. Yeah. You are subsumed in the union relationship, so the idea that there's a vested contract right is just gone. And it was really terrible. And so what do they do to stop this? During the war, the next year, there was Chief Justice Stone. What he did is he created a duty of fair representation. I don't know if you're familiar with that term. Yeah. Yeah, you know everything. So this is essentially a situation in which it said that you're going to have one union, but it has fiduciary duties to all its workers. Now, half the workers were white and half the workers were black. How good do you think those fiduciary duties were? Well, they were terrible, because the white guys always gave the plum positions to themselves, and the black workers always got the bad positions. Before they were forced into the same union by the Railway Labor Act that I just mentioned of 1926, the black unions used to compete with the white unions, and each of them got roughly half of a lolly, because the two workers' unions were about the same in terms of their overall competence and so forth. And so he says, now you have to treat the other guys fairly. Well, 11 years later, they're still arguing what counts as fair. Mm-hmm. And they can't get anything done because the skewed management is just a built-in impediment to fair sorts of representation. And when this came up in 1955, Hugo Black from Arizona knew very well what was going on, and he really laid it low into the union forces at this particular point of time, and the whole structure, in a case mainly known for its procedure. So this was a constant problem that existed in these unions, and this is all in the private sector, and there was really nothing that you can do about it. And then the National Labor Relations Act comes along, and it makes another vital decision, but fatal mistake. What they should have done with the Wagner Act is repealed it. It made no sense because of what it did. What they did, in effect, is they said 8.1 is now 8A1, 8.2 is now 8A2, where the A means these are unfair labor practices committed by management, and they introduce it in the 8Bs, all of the unfair labor practices that can be committed by unions, chiefly by essentially trying to monopolize the way in which certain industries would work. Well, as they say, two wrongs don't make a right, they just make a bigger mess in terms of the actual administration. And it was clear that things were starting to change, but it was because of several things. One is automation, and so routine tasks can now be performed by machines. Unions work best when all their workers are essentially doing the same thing for the same wages in the same situation. That's why they work well on assembly lines, right? But when you start having a situation where the machines take that over, and there's a greater variability amongst what workers do, it's hard for them to form a common front. Sure. Because if my labor is worth twice of yours, pardon my saying that, Dave, then I'm going to want more than you, and you're going to want equality, and you can see the tension will come up.
Well,
That was
it's another problem with the duty of fair representation.
yes,
Very similar to the racial issue. If you've got forced monopoly, you got a
yeah.
bunch of people who are in the same bargaining unit and exclusively represented. It becomes very difficult to have anything other than tyranny of the majority in that group of people.
And that means that this is the old fight between the AFL and the CIO.
Hmm.
The AFL were basically the skilled workers, and the CIO, the Congress of Industrial Organization with this vague Marxist overtone, represented rank and file workers with lower levels of specialization. And they had separate unions, and they used to fight all the way through the 1930s and 40s. They merged by 1953 because by that time they realized that the external forces, which was very difficult for them to deal with, were getting larger and larger. The change in the composition of the workforce, the greater sophistication of employers, the massive imports of foreign goods as tariff barriers and trade barriers are lowered under the GATT and so forth, puts them at a position. So they reached their basic peak in about 1953 with about, 30 some odd percent of the workforce. And it's been steadily downstream ever since then in the public sector. It's because the collective bargaining agreement can't deal with things outside of it. So if you're a labor union and you have a very expensive grocery store in good old Manhattan, and somebody wants to introduce a cheap place to come in and compete with you, Walmart or whatever it is, you now have to use the zoning laws to keep them out. And you will do that. So what happens is all of a sudden a lot of works of labor unions shifts away from the bargaining table, and they join with their employers, right, to keep out the rivals so that they can then divide the spoils of the monopoly arrangement. And this has happened all the time in a place like New York City, where in fact consumers are deprived of all sorts of cheaper things. Some of them go across the border into Nassau County or Westchester or New Jersey, but many of them are trapped there under these kinds of systems. And so the union problem in the private sector is acute. Now, I think we should get a little bit to the public sector.
Yeah, yeah.
Well, what happens is, as I mentioned to you, Roosevelt was opposed because he knew that they were on both sides of the table. The guy who wasn't opposed was John Kennedy. In January of 1962, he said, I'm going to recognize federal union workers for limited purposes to bargain. And what he did, therefore, is to create the very dynamic that you didn't want on the other side. You also had a no strike pledge that was built into this, right? Which was disregarded as often as announced. And then it started in the federal government, and it spread to states, including states like New York, at very high levels, with various statutes starting around 1962 or so forth. And all of a sudden, you now get this union kind of relationships in transportation where it's deadly. You get this union kind of relationships in education where it's deadly and so forth. And now what happens is the union will threaten a strike or a slowdown or something else. And it turns out it's easy for legislators to give away other people's money when there are no fiduciary ways in which you can stop them. And so you get larger unions, they're more powerful. And as they get more powerful, they impose further and further restrictions on the way in which these things can break. And so then the question is, can you do anything in order to slow down their particular operation? Well, in the earlier days, there was always the problem that when you dealt with a union, the bargaining table was half of what was going on, but the political arena was the other half of things that were going on. As I mentioned, for stuff like making sure that you get the right tariff barriers or protective barriers by the local governments and so forth. And so workers would start coming forward and saying, look, we have rights too. Now, what the world does that mean? Well, if you go back to the 37 Act and so forth, the previous rule said that you had a right to contract with your employer on terms that you see fit, and the imposition of a union monopoly was essentially a violation of that particular right. And so now when you go into the public sector, you have the same problem. In the private sector, what happened, they said, forget about all this fancy contract stuff, constitutional stuff. It's a huge government monopoly over this thing, and we set whatever the terms are because there's wide discretion under the police power to do what we will. Then you get a case called Abood, kind of a thoughtful opinion in the late 60s by, I think it was, by Justice Potter Stewart. And he says, there's a real problem here. because these guys are asking you to contribute money, not only for your economic betterment at the bargaining table, but they also want you to support a bunch of political things, but you, in fact, are very much opposed to.
Talking about the public employees having
Yes,
to contribute,
yeah. And so now there's this First Amendment claim that is a higher level of scrutiny, in which they're saying, look, I want to support political policies A, B, and C, and you're doing not A, not B, and not C, and using my money against me. And so what he proposed was that there be a segregation, and that you designate part of the funds as political, and the workers get an opt-out with the political monies, but not with respect to the economic money. Well, guess what happened? It's amazing how little political activity the unions pay when they're taxed. And so they start moving more and more things back into the bargaining side. And then you have to go line by line through a balance sheet to see whether it is or is not. Well, that's what you had to do.
I've done some of that. I mean, so the unions would categorize lobbying as part of the collective bargaining function, because what are they doing? They're going to the government, just like they did at the bargaining table, and they're asking for better terms and conditions of employment. They're just doing it by statute instead.
So you got it. I mean, and then everything else, advertisement, right? Well, we're trying to recruit unions. Workers, no, we're not trying to do that. We're trying to influence the legislature.
Right.
And so what happens is the numbers get smaller and smaller. And everybody realized that it's rigged, proudly on one side, not so proudly on the other side. So what's the remedy? And the thought was that the remedy would be we have tighter auditing of the line. It just doesn't work. It's a little bit like the duty of fair representation. When you try to make sure that the black workers are treated fairly, doesn't work.
Yeah.
Internal allocations like this are murder. So what they said is you have to have a right to opt out. And so in the Janus case, after much false starts, that's essentially what Justice Alito, who had always been a critic of the Abood case, said, these guys can leave. Or can they? Because you know what happened in response. Do you know what the Hotel California rules are, if you recall?
Oh, yeah, you can check out any time you like, but you can't never leave.
Yes.
Yeah.
You would always check out, but, you know, you could check out, and, well, when do you get rid of your dues? If you manage to file the application to have your dues eliminated between 12:01 and 12:02 on a Sunday morning, then you may be successful. Otherwise, you're in for another year.
Oh, yeah. So a bill was just passed in Louisiana, this weekend. We'll see what it looks like when it goes to the governor's desk. But during some of the hearings, one of the things that the bill was trying to correct was public employees' right to resign their union membership at any time. And unions would say, oh, no, they can resign their union membership at any time. And if you go and look at some of the forms they ask people to sign when they become a union member, that's actually true. They can resign their union membership at any time, but they have to continue paying dues, as they say, regardless of union membership status, until a certain window opens up each year.
And then
they have to re-raise their objection so that they can get out during that window. Of course, if they don't, they're in for another year without being a union member, but still paying union dues.
They understand this. And it's clearly manifestly inconsistent with what Justice Alito did, but it tells you one thing. If a union is organized, rearguard actions are always going to be possible, and there's no such thing as a decisive victory. That's why, in my view, the only thing to do, I will give you my approach, and I've said this for a very long time, a public union is a breach of a public trust. They're all unconstitutional. What does somebody mean by that? Well, you have to go back and realize what the public trust doctrine was about. And this was an ancient doctrine applied to public lands and to public waters and so forth. And the state had to be in charge of the waters because otherwise nobody could take care of pollution and sandbars and traffic rules and so forth. But what they had to do is to put themselves in a position of a trustee, just the way a corporate trustee is there. And the only rules that they were allowed to make were rules that were intended to make sure that the efficient operation of these public facilities was advanced. And there were two kinds of duties. There was care and there was loyalty. And what is the kind of arrangement that's a deviation from both of them? Is entering into a service contract for a public facility where your brother-in-law runs a company which knows how to run a dredging equipment and so forth. And you hire them and you pay them twice as much as they're supposed to get, because you don't take any competitive ends. And the rule is always that if you do that, You set that contract aside, and you require them to return the money, and you throw out the public officials who did it, right? Well, now, what's a union? It's another special interest deal. You can get any of the services that it provides for X for 1/2 X. But you pay it to them, and what happens is it's a breach of the public trust because they're doing something which is essential for public services, maintaining the roads, the rivers, or whatever it is, but they're basically wiping you out. And the public trust doctrine parallels that doctrine of corporate law, in which you have always fiduciary duties to act in good faith, and that the scrutiny is always heightened when it turns out there's an explicit financial conflict of interest between the outsider who's getting the money and the inside group, and you stop it. Well, that's what a union is. Yeah. They're the guy who gouges it. So the correct answer is the one that Calvin Coolidge put forward a long time. No public unions have the right anywhere to strike at any time, whatever, period. So you have to ban them and say that you compete. Now, the other thing that you have to do is suppose you've got 10 towns in town and they all want to hire teachers. They're not allowed to collude either. They have to be competitive on both sides of the market. And that will lead to higher outcomes for both groups. Everybody tries to cheat on it, both the employer side and the worker side. But that's what you need in order to make this thing work. What happens is the Hotel California rules and all the similar problems that we've talked about essentially fail or are countermeasures, which mean that half measures never work. And it's a kind of a general rule. I wrote a book once called Simple Rules for a Complex World, right? Mm-hmm. And the genius of that book, I like to think, was to say when you have a highway, you have the traffic going north on one side, the traffic going south on the other side, and you have a bright line in between, right? And you basically don't want to be standing on the yellow line in the middle because you get killed both ways. What we do in labor relationships is we basically set up a set of institutions that straddle that yellow line, which are bound structurally for failure.
Well, that's true. So many of the reform ideas that we work on throughout the country at the Commonwealth Foundation are, in a sense, half measures. It's a political reality that we have to deal with. But one of the enduring problems for us is that we set up some sort of complicated system to keep some of the union abuse in check. But how do you enforce that? Typically, the enforcement either falls on an attorney general who's still got the government problem, right?
Yeah.
Or it's on an individual who's maybe a union represented employee, and they of course have a very hard time navigating those rules by themselves without a lawyer present. And if they do have to hire a lawyer, it's it's incredible expense to go up against a bunch of union lawyers on the other side who are retained by the union at incredible expense, not only to the union, but to the workers, including that very employee who's trying to challenge the union.
Look, one of the things that I would say is union lawyers are, as lawyers, amongst the very best lawyers you'll ever find. I mean, they're devoted, I think, in many ways to the wrong causes, but they do have a kind of evangelical spirit about them, and they push extremely hard. Because essentially, unions function only well where the loyalties to the union dwarf every other lawyer. And so you start listening to the songs, right? I'm sticking with the union. This is an anti-scab song. They understand that the moment there's any defection within the ranks, what's going to happen? The whole system will start to topple. You're trying to create situations where the options out are there. The middle solutions of basically having them around and giving people uncertain rights to opt out get you situations that don't work. And so either you stay at a corner solution or you're at the other corner. Now, why is it that unions don't simply completely run roughshod? Well, there are a bunch of reasons. One is it comes to the point that if they become so aggressive and so abusive, there will start to be a public backlash. And whereas the unions can win in a political environment where there's low public participation, if they anger people by major strikes, and all of a sudden people who normally say, I don't give a damn what the union is about, it's just not important to me, they start coming out in force and you start having public meetings on it, they can't win. So sunlight is a disinfectant, and these guys generally like to work not in the complete dark, but shall we say in the twilight zone, right? Where there's a little bit of gray but not a lot of light. And they're very effective at that. And you start to see it. They're absolutely opposed to any kind of disclosure laws about what they have to do and the way in which they start to work. They're extremely active in shutting down charter schools in whatever way it turns out that they can possibly do this. They're religious institutions, they're biased institutions, and they try to create the following system where every non-union person in the public at large has to pay for a union institution, but every union person in the public at large is rid of any obligation to support non-union institutions. So they have a system of subsidies that are trying to flow in the direction in which they want to work. And so all of these things are essentially what's going on, and it goes back to the following proposition. If property rights are indefinite, it turns out intrigue will always do this, which is why, in effect, when you have a system of property right, you have one person or his voluntary compatriots in that one person who have the right to exclude. And the only time that you could overcome that is in cases of really abject public necessity, by which I mean a war or something of that particular sort. I don't mean, as Mr. Donald Trump seems to think, that I'd rather bargain one way rather than another way. Those things are not necessity. And if you keep to that line, unions cannot do particularly well. And so what they do is they keep pushing it back in the opposite direction. And the complication is, what happens is these groups can organize. They put on a certain degree of populist mentality. And in the great political realignment that has taken place in the last 30 years, right, many workers sort of inclined to be Republican. Mm-hmm. But they basically are in favor of more economic freedom, but they kind of still have a lingering affection for their own unions and their own situation. So the waters are muddy. It's, I think, a little bit easier, and Republican unions will be a bit less adamant than Democratic unions. But it's not going to be as though they're going to be, oh, let's just do the most wonderful thing possible. They're not going to be Mr. Magruder's union, who will put their best foot forward because they're so grateful to having the collective bargaining position that they'll never choose to exploit it.
Well, on that sad note, I think we should wrap up.
Well, thank you for having me.
Professor Epstein, I really appreciate you coming on. I would recommend the Classical Liberal Constitution. Fantastic work that helped me quite a bit. I've also got one of the oldies. I've got a Bargaining with the State book, which is not all about collective bargaining. It's real, but in a way, if you know about collective bargaining, it applies some of those concepts more generally to working with the government.
The book is about, and I'll finish with this last part, is the way in which we tend to think about government is that it imposes restrictions on people through coercive force. But today, that is not the dominant paradigm. Today, the pattern is that the government will bargain with you. So instead of imposing a zoning reputation which says this land is industrial and this land is commercial, they'll zone everything agricultural so you can't do anything, and there'll be a bargain. And they'll figure out how much land you could use and what are you going to get for us, this quid pro quo system. And bargaining with the state is an effort systematically to deal with the advantages of and the abuses of monopoly powers in the hands of a government. And unions are, of course, one of the topics where that monopoly power is the greatest. So that's what the connection is. It's the other side. I maybe should have changed. I wrote a book called Takings, if you remember, back in 1985. The first chapter in this book is titled Givings, and I think it probably would have been better if I made that the title of the book so that I could match them much more clearly than I did. But that was a mistake of over 30 years ago.
Well, thanks so much.
Okay, bye-bye.
Bye.
Terrific.